Workforce Advisory, Dean Cameron. Today we're looking at a recent matter regarding the full bench of the Fair Work Commission has dismissed an employee's application for unfair dismissal. The full bench of the Fair Work Commission has denied a terminated employee's permission to appeal against a determination that his dismissal was not harsh, unjust or unreasonable. The former employee had been employed by Toll Transport Pty Ltd as a casual truck driver for 3 years and 8 months on a regular and systematic basis. In April 2019, he was elected by his workmates as the Health and Safety Representative, or HSR, which involved raising issues and representing the safety concerns of workers. During June 2020, he attended 3 disciplinary meetings as a support person for a colleague who was facing allegations of misconduct. Following second and third meetings, the truck driver submitted a timesheet that suggested he worked from the time of the meetings up to and including the start of his normal shift. Being several hours later, he claimed as he had undertaken activities associated with his HSR role, not just a support person. Following an investigation, Toll decided to terminate him and provided him with a notice of termination on the 3rd of August 2020. He lodged a claim for unfair dismissal, which was heard by Commissioner Cambridge, who issued a decision on the 16th of April 2021. The decision was then heard by the full bench. Vice President Joe Kazmanzi and Deputy President Bull and Commissioner O'Neill. Essentially, the appeal rested particularly on 2 grounds. Firstly, Commissioner Cambridge erred by not considering whether the truck driver was entitled to be paid for attending the meetings, according to the State Workplace Health and Safety Act. Secondly, Commissioner failed to follow established principles where finding the truck driver engaged in serious misconduct by deliberately falsifying his timesheet. The full bench rejected the first claim, determining that the Commissioner indeed did make a finding that the truck driver was not entitled to payment by the relevant legislation. Further, Commissioner found that the truck driver did not attend the meetings on the basis of his HSR role. With regard to the second claim, the full bench acknowledged that the Commissioner had appropriately determined, based upon the evidence presented, that the truck driver did not generally believe that his attendance at the disciplinary meetings involved legitimate HSR activities. Consequently, the full bench determined that it would not be in the public interest to grant permission to appeal. If you've got questions regarding HSRs, please don't hesitate to give us a call. Dean Cameron.